Welcome to the Tech and Space Leader Show, where we learn lessons from leaders of the next frontier. I am your host, Lisa Dreher, and I'm really excited to introduce our guest for today, Steve Wood. He is Senior of Counsel at Vela Wood. Welcome to the show, Steve.
Thank you, Lisa. So glad to be here. Very excited to share my knowledge in this domain with your viewership.
Thanks so much for making time for this. So maybe you can start by giving us a little background on yourself and Vela Wood.
Certainly. So Vela Wood is just going on 16 years old. It was started by founding partner Kevin Vela and later joined by my brother, Radney Wood, who is one of the named partners, of course, and also manages our Austin office. For myself, my background, I've always kind of been a bit of a science geek, science nerd. And so ultimately just kind of followed that initially through earth sciences and undergrad. Kind of came back to school with a renewed interest in the physics and engineering side of things and figured it'd be pragmatic to pick up a law degree at the same time. And so I wound up kind of specializing in patent law, intellectual property, technology commercialization. And I've held various roles with the patent office as a patent examiner, Brookhaven National Lab, Leiden University and their tech transfer office, Loris, as well as most recently State University of New York Research Foundation and their tech transfer office, which serves close to 25 plus campuses across the New York system. So that's about 2 years ago now. I separated as I was running one of our SUNY Polytechnic at the time. Now we've folded back into SUNY Albany at the College for Nanotechnology, Science and Engineering, CNSE. And we have the nation's foremost academic semiconductor research center there, where Intel has developed their previous, 14, 7, 5, and now working on 2 nanometer node transistor technology. And it's a place where you can dirty up the fabrication line. It's a research line, and academics use it. Big industry uses it. It's a great collaborative facility, but we wind up very well positioned then to undertake, various research activities at this forefront of computer technology, and one of those being Air Force Research Labs funded research on neuromorphic computing, which I work with now. I ran that tech through several business accelerators, as I was saying, starting back in fall of 21, summer 22. I separated from Research Foundation, kind of came on board more formally with Vela Wood at that time after I had concluded those business accelerators. I learned a lot. I did not really kick off the startup at that point. It is still very much neuromorphic technology, still very much an emotive development. What I learned was non-volatile memory. ReRAM, ours is a ReRAM based neuromorphic hardware. It's kind of having a moment. Somebody, in the last 2 years made ReRAM out of honey. And then there was an Italian and Austrian research team that published a world's first on quantum optical ReRAM. And with neuromorphic systems, we're talking about like event-based cameras, hardware spiking neural networks. And for some reason, spiking neural nets, they're much more akin to our own biological systems, and they inherently sparsify, make as small as possible the data collection, transmissions, and processing. We can achieve similar results to the large cloud-based models with 100 times fewer neurons in the system and 1,000 times less power.
Wow. Okay.
So I'll just and so I kind of split time between Vela Wood, where my legal hat, and then State University of New York, where I work with that research team supporting their research efforts, kind of in an administrative capacity, but also it helps me stay very close to the development side of things.
Okay. So that's a lot to unpack, and you're using a lot of really interesting words and phrases that maybe not everybody's familiar with. So maybe we can unpack that a little bit. But I really just want to start with some simple basic stuff. And that is just, what is, you're kind of known as a space lawyer. What is a space lawyer and what areas do you focus on?
Sure. So, a good friend of mine, Bailey Reicheld at Age of Space Law, um, it's all the time reinforcing and reminding. And I absolutely agree that space law is kind of a domain where it's not so operationalized. There's five international treaties. The first four are really the primary core. The Moon Treaty, negotiated between the U.S. and Russia primarily through the 70s, ultimately failed, and by comparison to the other treaties, with the U.S. and Russia both walking away from that and just kind of throwing up their hands. And that is a bit because that treaty included very similar provisions to the UN Convention on the Laws of the Sea, which stipulate that revenues from deep sea mining must be shared with all, economies because it's a global heritage, if you will. And similarly, the Moon had a similar stature under the Moon Treaty. And at the time, those two powers just felt like they couldn't make that work, and maybe didn't want to make it work, and so walked away. And so we're left with these four treaties, really, plus a lot of UN guidelines, space debris mitigation. There's a lot of soft law, but in terms of hard law that really establishes treaties, we've got those four main treaties: the Outer Space Treaty, Registration Convention, Agreement on Rescue and Return, and the Liability Convention, not in that order. But those four treaties really lay the framework and the ground rules for how the parties to those treaties, nation states, operate in space. And part of that is providing authorization and supervision, so like FAA licensing of space activities, payloads, et cetera, for their respective nationals that are also private entities operating in space.
Right, right. So what do space companies and maybe startups in particular really need to consider when it
And
comes
so the
to working in
operational
space?
side
Yeah.
The operational side is very much more like along the lines of FAA licensing activities, FCC licensing activities, export controls, CFIUS reviews, these kinds of things that are really relevant and regulatory requirements for these companies. Whereas the space law side of it is really, again, more kind of that framework. And of course, there are certain parts that will potentially have very real world consequences. Liability convention, for instance, it's never been litigated. And there was one instance, I think it was late 70s, the Roscosmos satellite that went down over Canada. And, having looked at it a few times online, there's a wide range in terms of what the damages were. Supposedly, the total actual damages versus those that were requested and claimed versus those that they actually settled for. I think it was somewhere around 3 million out of potentially a couple $100 million in actual damages. So, but that was settled and never litigated in terms of liability. There's been a few other instances as well. The Iridium satellite collision, I believe that was a Russian satellite as well, and I'm going to forget the name of that one. But again, it's never been litigated. But as we become more and more active, it's almost a certainty that something will happen that will implicate the need to actually litigate under those treaties. Registration convention as well, but again, that registration, and we'll see later on how registration is important for IP, but that registration, for instance, in the US is typically handled as part of, say, the FAA payload licensing process. And so although there are attorneys who do some things that are maybe somewhat operational under space law, in the vast majority it's going to be under domestic national law.
Got it. Okay, so let's actually, you mentioned IP. Let's jump into that patents and IP side of things. What are some of the considerations that we need to be looking at as we are, bringing new solutions to market that are, meant to be used in space?
Indeed. And so it is very situational dependent. I'll start off with the classic attorney answer there. It depends. And so the typical considerations for patents are usually going to be, with respect to a technology that's going to be deployed anywhere, where is it most likely to be made and manufactured, mass production, and where is it most likely to be consumed? What are the most likely, largest target markets for it? And then you can kind of home in on the appropriate jurisdictions where you want to pursue and obtain patents, all the while keeping the budget in mind, because filing in foreign countries through even the PCT International, the PCT is nice. It kicks the can down the road on a lot of the fees by 18 months, but it also does have the required national phase, where when you go into the national stage and file in foreign countries, you could be, if you're filing in 10 plus foreign countries, you could be looking at upwards of 200K in patent fees, in translations and everything, just to get filed. We're not even talking prosecutions.
Yeah.
And so with respect to technologies that will be deployed in space or used in space in some capacity, we also have this arcane affirmative defense to patent infringement under the temporary presence defense. And I'll just share my screen here briefly, if that's all right.
Yes.
I'll bring that up. This is a poster that I originally shared as a Valentine's card to the space industry, and it's also up on my LinkedIn, and so anybody can go up there and find this. And so this is really kind of a visual roadmap, a summary of the temporary presence defense, which was originally kind of conceived in the mid 1800s, early 1860s, originally in the UK. It was a Dutch vessel that entered their territorial waters to conduct business, infringing a patent, I believe, in a screw propeller. And ultimately, it went up to their highest court, and they held that, the fundamental tenet of international law is you must obey the laws of the country in which you find yourself. You're infringing this UK patent, Dutch vessel, Van Vlissingen. So, sir, pay up. You're guilty as charged. The very next year, Parliament passed this temporary presence defense, whereas in the U.S., ours came about through almost a situation kind of similar to Marbury versus Madison, where the Supreme Court read in judicial review into the Constitution. In this case, it was the Patent Code, but they read into the Patent Code this temporary presence defense, and they essentially said the framers of this legislation could not possibly have intended to give an individual patent holder the right to frustrate international commerce. And so if a maritime vessel, if a foreign truck, rail, air, aviation, and of course also now space, if any of these vehicles enter our territory temporarily for the purposes of doing business, they can potentially take advantage of this temporary presence defense. So apologies on the long wind up there, but this really comes to a head in Hughes Aircraft Co. Versus US. And that is this instance here, if I can get my magnification right. And
there you go.
I also have to get to the right column. And here is Hughes. And so essentially with Hughes, there were 5 infringing satellites made in the UK and Europe. The Germans were a partner to this as well, as was NASA. And 5 infringing satellites were imported and launched by NASA. Hughes only had a US patent. And as you can see, the case was ultimately decided in 1993, originally filed in the 70s and litigated throughout, originally included hundreds of satellites, but it came down to these 5 in satellites that were deemed to be otherwise infringing, that were made in the UK and imported and launched by NASA. And so ultimately it comes down to at the top of the poster, I'll zoom out again so that we can take a look at that. But there is a definition for vehicle in the patent code that was effectively changed by the 1982 revised NASA Act that expanded the scope of definition for vehicle to include any object intended for launch. That gets you past the import right on patents. It's intended for launch. It is intended for launch, launched, or assembled in space. And so, as you can see here, not just this instance in Hughes where the satellite is launched and deployed on orbit, and it is foreign registered here. That's an important point. You can see over here, I've got the similar situation where it's registered in the US, but if it's made in a foreign country and there's a US patent and it's registered US, that would technically be an infringement. That's kind of the opposite case with respect to the infringement there. But again, this 1982 revised NASA Act changed this definition, which made it then so that any article, any item that is imported to the US and placed in the cargo hold of a launch vehicle is now considered part of that vehicle for the purposes of this temporary presence defense analysis, which then has certain implications because under no circumstances do we provide that these objects cease becoming vehicles once they are in space. And so there's potential implications here with respect to enforceability of patents that I think are really important, especially for U.S. government, startups, and universities who are the most often in the position of only being able to afford U.S. patents. They really need to take this into consideration because in Hughes' position where they only had a U.S. patent, this was the outcome. But if they had had a UK patent, they could have enforced in the UK and stopped the whole issue at the outset over there before they were even exported to the US. And so the US goes a little bit further on this topic than many other countries. For instance, the French code says, in translation, something along the lines of, the rights granted under patent shall not apply to objects launched into extra atmospheric space. And so they do not specifically have any provisions for objects assembled in space, whereas we do. We include objects assembled in space under this temporary presence defense. And you can see my last three windows here in the graphic really illustrate those circumstances where if infringing goods and products are made at non-US bases, they can theoretically transit via reentry into U.S. territory and have a single transshipment transit to a foreign jurisdiction. Now, just consider the fact, when we're talking about it's an International Trade ITC, I believe, and then ITC would issue an exclusion order to Customs and Border Patrol if and when we know about infringing patented goods that are entering the U.S. But we're really bad at patents and trade secret protection from that end because it's really hard to know. That IP is usually embodied within a product that it may be difficult to see on the face of it whether it's infringing, whereas copyright, at least in the case of printed or other types of physical expressions, can be relatively easy to identify as trademark. But we have not great infrastructure for preventing the import of infringing patented goods. Of course, if somebody gets, if a company gets wind and they take an infringing product to TAEUS, they can then go and get that exclusion order. But it's really hard for us to know up front, even when a shipment of potentially infringing goods may be coming in. So I'll just say here real quick, we don't have great infrastructure on the incoming side. We've got essentially no infrastructure to really determine on the outgoing side, although I have spoken to experts and they have assured me that if such tech were export controlled, it would not get that free kind of transshipment under the patent law. But as you can see here, again, it really revolves around whether it's coming to the location for local use and consumption. And so if it's coming to the U.S. And not being transited, that's not appropriate. The only circumstances where that is if it's intended to be exported from the U.S. and it has been made at a non-U.S. facility. Then it can get around the situation where there are only domestic U.S. patents. But again, we don't really have the ability. Who knows if there's a patent in that foreign jurisdiction where it's going? We're not really looking that up. So I'll pause there. I know that's a lot, and I'll just invite anyone who's further interested, please get in touch with me on that, and I'd be happy to walk you through any particulars that might be relevant to their specific situations.
Right. So let's kind of reel this back in and talk about what are some of the biggest mistakes that you see companies make as they are, getting ready to launch a new technology into space or what have you. What are the biggest mistakes or pitfalls that they run into, and how can they avoid those?
Well, that is rife with all sorts of potential, right? So on the tech development side of things, space is well known for just having those longer development time horizons, those longer commercialization and monetization timelines. You need investors who have that kind of longer time horizon appetite, the higher risk appetite. And, when it comes to patents, I see folks often make mistakes around buttoning up their assignments, making sure that their employee and contractor inventors are all on appropriate IP assignment obligations, especially when it comes to software. There is special magic language for those contracts. And so when it comes to using vendors for software development, I've seen horror stories where the client has paid a vendor, lots of money to develop a platform, but they didn't have the magic language in the contract. They just called it a work for hire. But under U.S. copyright law and the courts, the software is not a work for hire via a vendor. It is if it's an employee. But so there's subtle nuances here that you really need to pay attention to. Or in this one case I'm thinking of, that client had their platform held hostage by their vendor.
Oh, wow.
Yeah. And so the ownership can be, and that was legal. That was essentially legal extortion, to that you got to pay us more to get your platform back.
Oh my goodness.
So
okay.
Assignment, as well, you really need to be thinking about, again, back to those strategic considerations. Where is it most likely to be made? Where is it most likely to be used and consumed, as we saw in the graphic as well? And then also with respect to space, where is it most likely to be launched from, or where would the facility wherein it is located, if it's either part of that spacecraft or if it's an item within the spacecraft, where would that facility most likely be registered? And so that's a challenge, because under the Registration Convention and Outer Space Treaty, any country in the world can procure or pay for a launch, procure those launch services, and they can become the state of registry. And so there is ample opportunity for kind of flag of convenience type behavior and activities here, but it is somewhat more constrained by export controls and FAA licensing. There's nuances there too with respect to if you're a U.S. person affiliated with a foreign entity, you may not need to get a FAA license for a foreign launch. But if you're a U.S. entity conducting a launch in a foreign jurisdiction, you absolutely need to get that license. And so there are other mitigating factors, but it is a real kind of multifaceted, multidimensional analysis.
Yeah, indeed. Well, Steve, I want to thank you so much for being here today. I feel like we've barely scratched the surface on this topic, so we might have to have you come back and we'll just, pick a certain area and dig into that area a little bit deeper. But if somebody wanted to learn more about Vela Wood or all of these topics that we've just barely touched on, what should they do?
Certainly. Please go to velawood.com is our website there. If they're more interested to learn about neuromorphics, I would recommend looking up the Dr. Nate Cady Research Group at SUNY Albany CNSE.
Excellent. Excellent. Well, thank you so much for being here today. We really appreciate all of the expertise that you shared with us here today.
My pleasure, Lisa. Thank you so much.
Absolutely. And I do want to take a moment to thank GuideForce for hosting these sessions. If you'd like to learn more about GuideForce, visit guideforce.com. And we'll see you next time on the Tech and Space Leaders Show.